All right. So hello, everybody.
Hello.
Hello.
Hello, and hello to anybody watching online. And welcome. So the purpose of this training today is to get us all up to speed on what changes are happening with regard to the public charge issue. All right. And some changes that have gone into effect or that are about to go into effect. All right. So we're going to go through this. So I'm going to talk about public charge, like what is the law. I'm going to talk about what changes have happened, how do these changes affect our clients. All right. And that's basically all we're going to get to. And that's basically what we need to know. All right. So public charge, right? There's a public charge issue that causes people to become inadmissible, and then there's a separate one that causes people to become quote unquote deportable. All right. But for all of this training, I'm talking about inadmissibility, not deportability. All right. So let me just say that. All right. Immigration Nationality Act Section 212A4 says this: any alien who, in the opinion of the consular officer at the time of the application for a visa, or in the opinion of the Attorney General at the time of an application for admission or adjustment of status, is likely at any time to become a public charge, is inadmissible. Should I read that again? The way the Immigration Nationality Act was written back when it originally passed, which the first version passed in 1965, right? All right? Says this: any alien who, in the opinion of basically any of the officers, is likely at any time to become a public charge is inadmissible. Any alien who is likely at any time to become a public charge is inadmissible. Any of our clients who at any time is likely to become a public charge is inadmissible. No waiver, case denied. All right, we clear? All right. So the second section of that lists various factors, because any officer can make that opinion, right? But they can't just make some crazy opinion. They're supposed to actually look to something. So the very next section, 212A4B, says, in determining whether an alien is excludable, under this paragraph, the consular officer or the Attorney General shall, at a minimum, consider the alien's age, health, family status, assets, resources, and financial status, and education and skills. And then down below that list of factors, it says, in addition, they may also consider any affidavit of support under Section 213A, all right, for the purpose of exclusion under this paragraph. Norberto is a pro at filling out what we call the affidavit of support, all right? The affidavit of support is a form that has been used to basically show in a case that, look, this person's got financial backing covered, all right? Right? They have money. We're showing somebody's signing off, saying that they're declaring that they're going to be responsible if the client ever ends up needing welfare, essentially. All right. What does all this mean? USCIS defines the term public charge as an individual who is likely to become, quote unquote, primarily dependent on the government for subsistence. And I need to have my second quote right there, sorry. Or no, it's at the end, sorry. Primarily dependent on the government for subsistence, and it says, as demonstrated by either the receipt of public cash assistance for income maintenance or institutionalization for long-term care at government expense. All right. The words that I have in italics and underlined right here are the buzzwords that we always hear about whenever we go to trainings on public charge, all right? Are they primarily dependent on the government for assistance? If they are, they're a public charge. If not, no. All right? And so that's been the advice, like stay away from welfare if you're going to be applying for a green card. All right? Even if you have legal eligibility for it, because you've got a social and you've got TPS and you've been here forever or whatever, or you've got a social and you've got asylum and you've been here forever. Often the advice is stay away from welfare if you plan on adjusting status. All right. So that's the way the law has been. Now I want to talk about what's changing. All right. On August 14th of this year, Trump, not just Trump, but really the Department of Homeland Security has made a change. DHS published a final rule into the Federal Register, all right? According to that final rule, these changes will go into effect October 15th, all right? So the new rule, this needs to be very, very clear, and I can shout it out to everybody and everybody on the internet, right? Those rules do not affect cases that are pending right now. Those rules do not affect cases that are filed before October 15th. The rules go into effect for cases that are postmarked after October 15th. Does that make sense? So if somebody's used any form of public assistance in the past, I would recommend they file their case now before these rules go into effect, because what we're about to see is an expansion of the factors that officers can use to determine that somebody's a public charge. All right, what do officers look for? Proving someone is not likely to be primarily dependent on the government, right? That's the primarily dependent language is the key language. Officers will consider that, they'll say, has an applicant ever used TANF, which is Temporary Assistance for Needy Families, all right? That's the federal term that we often call welfare, all right? SSI, long-term institutionalized care. Officers have always considered this, all right? In the past, officers would not typically consider whether somebody was receiving publicly funded health care, whether or not someone was receiving publicly funded aid regarding their nutritional needs, whether or not somebody was receiving publicly funded housing programs or Section 8 housing. Everybody clear on that? These used to not be part of the typical officer's analysis as to whether or not someone was a public charge, all right? In the new rule, these factors will be considered, all right? This is a drastic policy change. All right, what does it specifically change? Now, instead of defining a public charge as a person who is likely to become primarily dependent on the government for income and support, the new rule defines a public charge as a person who, for more than 12 months of any 36-month period of time, has used any public benefit. All right? And each benefit counts towards the 12-month calculation. What the new regulations are saying by this is imagine somebody uses temporary assistance for needy families for 3 months, from October, November, December, right? Because they needed it, right? And then imagine somebody was on Section 8 housing for 8 months. Section 8 housing for 8 months. All right? 8 plus 3 is 11. They'd be fine. It's not automatically fine, but it's not like an automatic, they are, there's evidence that they are a public charge. All right? But if somebody used TANF for 4 months and used Section 8 for 8 months, even if it's in the same 8 months, everybody could see how that could happen, right? Yeah. That person is now, according to this, a public charge, and their case will be denied. Does that make sense? Mm-hmm. All right. Good. Did I go backwards? Sorry about that. So for more than 12 months of any of the 36-month period of time has used any public benefit, each benefit counts towards the 12-month calculation. So if you use 2 benefits for 6 months, that equals the 12 months, right? Same over here, right? So the rule expands the list of publicly funded programs that immigration officers will look at to include food stamps, Section 8 housing, all state and local cash assistance, all right? This issue here, all state and local cash assistance, is what is the subject of now 13 different states suing the government about it, all right? As to whether or not, like, San Francisco City can't give out cash aid to the people that live in their city, right? Anyway, there are still some very, very important exceptions to all of this. Benefits received by the immigrant's family does not count. If you're an immigrant mother and you have U.S. citizen children, your children have the absolute right as U.S. citizens to get any benefit that they're entitled to, all right? Medicaid received by applicants while under 21 doesn't count, or while pregnant doesn't count, all right? Who was it that we had a consult just yesterday? I just researched this last night. So she's gonna be fine. She's pregnant. She's 7 months pregnant. She's worried about this issue, all right? Emergency access to medical care or natural disaster relief does not count. So if somebody's nervous because they just broke their leg, go to the ER. It's not gonna affect your green card. We'll just have to explain that it was an emergency. Okay. This font is really, really small. Sorry about that. How it works. The officers weigh factors, all right? They're supposed to apply this totality of the circumstances balancing test before issuing their opinion as to whether or not somebody is or isn't a public charge, all right? So they're looking at the 12 months of public benefits in any 36-month period. That's called, by the new regulations, a heavily weighted negative factor, all right? Heavily weighted negative factor. If you want to overcome a heavily weighted negative factor, you should certainly have at least a heavily weighted positive factor, all right? And we've got to look to that, all right? So other potentially negative factors might include medical conditions, past use of immigrant fee waivers, all right? Be aware of that, it's written right in there, all right? Lack of English proficiency, age, employability of the applicant, all right? Positive factors can be the reverse of those things. If you're 100% healthy, if you have English proficiency, and the one that's really in there as a positive factor is if you can show you have a household income that is at least 250% of the federal poverty guidelines. All right? Adjustment applications will require additional, okay, this is true. So this is actually, Roberto, this will affect your cases. The regulations are requiring an additional declaration of self-sufficiency for each client. They have to declare, I'm going to be self-sustaining.
So it's another form?
It's not another form.
No.
It'll be added to the instructions. It'll be added to the instructions of the I-485, and it's going to say you need to have a separate statement, be a one-page statement saying I declare that I'm self-sustaining. Yes?
Just to make sure, this doesn't affect people in removal proceedings?
It will affect adjustment applications in removal proceedings if those adjustments are filed after October 15th, 2019.
Okay, so only adjustments?
Yeah, correct.
Okay.
Correct. This is not a change, so thank you. We'll clarify that. How does this affect our clients? All right. So let's talk about who it does not affect. All right. So this change only affects somebody applying for admission or adjustment. Is everybody clear about that? So if you're applying for a green card or a visa, this will apply to you. But if you're applying for asylum or for naturalization, which we'll talk about, or TPS or DACA or parole or some kind of humanitarian benefit out there, all right? These regulations do not directly apply to you. Everybody clear on that? Okay? If you're applying for AOS, adjustment of status admission, right, through adjustment of status, through the U visa, T visa, or through asylum, waivers are available for this. So if you've been a public charge in the past, but you're applying for adjustment through a U visa, right, it's very waivable along with all things that are waivable with a U visa. Any questions about this? All right, does that answer your question, Naomi? So cancellation of removal applicants, you're not even subject to any of this. All right, yes?
If they've asked for help in the past, but then they can see like for a couple of years they've been self-sustaining, does it still affect them, or how back do they see the history?
That's a good question. I don't actually know the answer to that. I don't know if they only look back the 36 months. I think that it says, I mean, the law is written at any time. And so what I think is gonna happen is if there's 12 of any 36-month period, it will be a quote unquote heavily weighted negative factor, even if it was 10 years ago. And we'll need to overcome that. And so right here, the advice, right? The advice for our clients, the advice for those that are watching at home or whatever, is to let's advise clients to, whenever possible, bolster their positive factors, right? If they've got use of public benefits in the past, then now it's time to start thinking about how we can advise them to start showing things, how they can start to overcome it. Study English when possible, apply for a better job that pays more. I don't know how to do that. Use public benefits very temporarily and only in serious emergency type situations. If people understand that, hey, once that 12th month hits, now their green card application is going to be denied. Okay, let's just get you on whatever program that you really need for 11 months. And let's stop there, and in those 11 months, let's look for any way possible to improve the situation, all right? Do not use 12 months worth of benefits in any 36-month period, right? Or, big or, apply now, like before October 15th for your green card, if it's possible to.
Mm-hmm. I have a question.
Yes.
So, let's say they did TANF from January to June of 2019 and Section 8 from January to June of 2019.
Yeah.
So that's 12 months.
That's 12 months.
Even though it's the same time period.
Correct.
Even when it overlaps.
Even when it overlaps. Yes. That's right.
Question.
Yes.
I'm a little confused as far as the waiver for, like, let's say, hypothetically speaking, someone applies for asylum, so it doesn't necessarily affect them then, but like a year, like let's say, their asylum case is granted,
Yep.
a year later they can apply for asylum AOS, then is when there's a waiver available for
Yes.
that? Okay, so it's
Asylees that are going through an adjustment process are legally, they still go through 245A of the Immigration Nationality Act, which is different, for example, for T visa or U visa holders. But they have lots of fairly generous waivers at that time to avoid certain inadmissibility grounds. Okay?
So you can receive benefits like up to 11 months every 36 months then? Once?
No. Well, yes. Actually, yes. So, did everybody hear that? So theoretically, you could be on welfare, theoretically. I don't recommend this to our clients because this will cause issues. But say a Section 8. Section 8 is a much, it's a lesser problem for immigration officials, all right? But say somebody receives Section 8 housing benefits from January through November, 11 months, right? And then they get out of there and they wait 3 years. And now they get on Section 8 again for 11 months, and then they get out of there, and then they wait 3 years. They haven't triggered this. Does that make sense? Yeah. Okay. Yes.
I guess I just want to make it clear to our clients that most of our clients, even now and even after October 15, will not trigger this. It's more of a fear kind of like tactics by the
True.
government.
True.
Because our clients, for the most part, don't qualify if they're undocumented
Correct.
for most of these benefits. And you know, like you said earlier, even if they do receive these benefits, it's because of family members
Yes.
and or kids.
Yes.
Especially, I get questions all the time about Medi-Cal
Yep.
for the kids, week for the food assistance program.
Mhm.
And I tell the clients, like, your kids, your children, your family members, if they're green card holders already, or if they have a U.S. citizenship, they more than, you know, they're
Yeah.
legally able to apply for as many benefits as they can.
That's right. That's
So-
exactly right. Thank you for saying that.
Mhm.
Yeah. A lot of this is fear. A lot of this is just like, hey, let's scare everybody out of even applying for a green card when people are completely eligible for green cards. And so thank you for saying that. And our job is that, like, hey, let's look at it carefully. Let's see if they did actually trigger this. And if so, it's not the end of the world. Let's figure out a strategy for how to improve it. You know what I mean? What it will likely cause, if there's been use of benefits in the past, what it will likely cause is, okay, we'll need to come up with a strategy or a plan to, like, improve their positive factors first before we can file. Does that make sense?
Well, people that are Medi-Cal. That's also.
Yeah. Yeah.
But again, I don't think they're eligible
Correct.
Yeah.
unless they're pregnant, which is excluded.
Yeah.
And then the children who are U.S. citizens or LPRs or have that right.
But there's
To
like
receive those
emergency
benefits.
Medi-Cal.
Emergency
I remember when my
Medi-Cal,
grandma.
emergency Medi-Cal does not
Yeah,
count.
emergency medical does not count, yeah. Yeah, emergency only, yeah, that's fine. Good questions. Any other questions?
So for Nats, we're gonna go into this account.
NATS is not affected by this directly. That's the issue that I mentioned at the beginning, that there's also a public charge deportability ground. The deportability ground of this affects people that are applying for NATS. But right now, these regulations are not addressing the deportability ground in section 237. It's only addressing the inadmissibility ground in section 212. So right now, there's no effect of any of this on NATS cases. Does that make sense? Cool, very good. All right, so there is more to come. As I mentioned, 13 states have sued over this, all right? And so the suit argues that DHS's change is an abuse of discretion because it reverses a decades-old consistent policy without reasoned analysis, all right? We'll be following this lawsuit, obviously, but we also want to be prepared for October 15th in case there's no injunction that stays, right? So that we're ready for when these regulations go into effect, if indeed they do. That's it. Any questions? Very good. All right, and for those that are on the internet, if you are watching and if you are like nervous about all this, like get answers, right? That's kind of what this presentation's about. It's what our whole office is here to do. Like, call our office, come in for a consultation. Let's see if any of this even remotely affects your case. If it does, let's apply now, not later, so that we can get it in before the October 15th deadline. And if it doesn't, like, let's get the information so that we know how we can get your case approved or give you the strongest case possible. Thanks, everybody.